This video is an overview of you and your child's special education rights surrounding school discipline and private school placement. It will seek to answer and explain the following. May my child with an IEP be suspended or expelled? Manifestation determination meetings, and procedures surrounding private school placement. Let's begin with the first question about suspension and expulsion. May my child with an IEP be suspended or expelled? This is not a simple yes or no answer. A student with a disability can be subject to the same disciplinary actions for breaking school rules as any other student. However, every student with an IEP has unique needs that should be considered when school officials are taking or considering taking disciplinary actions. So this is dealt with on a case-by-case basis, rather than a zero-tolerance policy, as the codes of conduct may dictate. This is because your child's disability may impact their ability to control impulses and reactions to their environment, and even understand consequences. Other things the district may consider is your child's history of behavior, and supports that were in place or not in place before the behavior took place. Because a decision to suspend or expel a student leads to a change in a child's educational placement outlined in their IEP, there are procedural safeguards within the IDEA that outline what must take place when a student is removed from the program placement for more than 10 days. No additional processes are required by law if your child is removed from their IEP placement for less than 10 days. If your child is suspended for more than 10 days in the school year, the district will need to provide services on any days after day 10 in order for your child to participate in the general education curriculum and to make progress on their IEP goals. In addition, an IEP meeting will be held within 10 days to determine if your child's behavior at question is caused by their disability. This meeting is called a manifestation determination, or MD, and you will be invited to participate in the meeting with a meeting notice. The meeting will determine if the behavior is caused by the student's disability and may consider adding or changing behavioral intervention services provided by a behavior specialist, a behavior intervention plan, or BIP, goals to address your child's behavior, and/or asking your permission to conduct a functional behavior assessment, or FBA. If the manifestation determination meeting concludes that your child's behavior was not a manifestation of their disability, the district may treat the offense in the same manner it would a child without a disability, i.e., continued suspensions for that behavior and/or expulsion. If you disagree with the MD's conclusion, you can request an expedited due process hearing that must take place within 20 school days of the date you submitted the request. Again, no matter where your child is during their suspension, including at home, after 10 days the district must allow them to continue to participate in the general curriculum and provide them the services and modifications in their IEP. When you place your child in a private school, they can still receive services from the school district in which this private school is located when the district is given proper notice of your plan to enroll them in a private school. To notify the district that you are removing your child to attend a private school, tell them at an IEP meeting or by giving them notice in writing at least 10 business days, including holidays, before removing them from a public school. However, the district is not required to provide some or all of the services necessary to your child in order for your child to have a FAPE. The district will consult with the private school and you to determine the services that could be offered to your child if you enroll them in a private school. If your child was receiving special education services in CGUSD and you enroll your child into a private school without the consent of or a referral by CJUSD, the district is now required to provide services to your child if FAPE was already available to them in their IEP in the district. If you think that your child was not provided FAPE by the district before you enroll them into a private school, by filing due process you can have your case heard by a due process hearing officer or court. If the court or due process hearing officer agrees with you and finds that the district failed to provide your child a FAPE while enrolled at CJUSD, and the private school where you enrolled your child is appropriate for your child, they may reward you with the reimbursement of your child's private school tuition. The court or hearing officer may reduce or deny the amount of tuition reimbursement if, before removing your child from CJUSD, you did not make your child available for a special education evaluation after the district gave you notice through an assessment plan, and you did not tell the district that you were rejecting the special education placement offered by the district. This includes your concerns about the proposed placement and your intent to enroll your child in a private school at the district's expense. If you have failed to provide the district with the written notice stating that you plan to enroll your child into private school because you feel that they are not receiving FAPE at CGAUSD, the court or hearing officer will not reduce or deny you the reimbursement for your child's private school tuition. If the school prevented you from providing notice, you did not receive notice of your procedural safeguards, or otherwise been told that you needed to notify the district, providing notice would have likely resulted in physical or emotional harm to your child, or illiteracy and inability to write in English prevented you from providing notice.